to begin with, we need to understand that eminent domain and the power and the authority for eminent domain comes from our federal Constitution. It's one of the powers and rights that were incorporated into that federal Constitution, and has basically, in various forms, also been incorporated into each one of our state constitutions. Every one of the states have also enacted laws or statutes that spell out how the rules for eminent domain are to be applied in each particular state. While the basic premise of eminent domain is pretty much the same from state to state, the procedures and the nuances will vary from state to state. So depending upon what state you're in, some of the things that we'll be talking about as we go through this series may vary. But the general rules that I'll be talking about will be applicable really everywhere you go. One of the key things in understanding eminent domain is that even though the law emanates from the federal Constitution, unless the entity which is taking the property happens to be the federal government or a federal government agency, all eminent domain cases have to be brought in state court. And the court proceeding is held in the county where the property is located. Now, in those proceedings, many states will allow the determination of damages that you as a property owner are entitled to recover to be determined by a jury. Some states, however, do restrict that to having that determined only by a judge. Now, when the property is actually taken from you, the right to take property, one of the things that is a complaint or a fact, I guess, or a statement that I hear many times from people who are affected is that they feel intimidated by the process. And the only thing I can tell people, and I will say that now up front early in this series, is that the use of intimidation, for better or worse, unfortunately, is kind of an environment that we see happen all too often. I tell people, and I encourage people to try and ignore the intimidation and realize that the reason sometimes intimidation, in my mind, is practiced by condemning authorities is that they want to put the fear into property owners that going through eminent domain is not a good thing. But I try to explain to people, and as you look through and as you view this series and understand the eminent domain law better, you'll see that it doesn't have to be intimidating. In fact, what I try to explain to people is that the laws of eminent domain actually give you, the property owner, a lot of power and rights that you can use against the condemning authority to make sure that you're not abused in the eminent domain process. But you do have to stand up to them. And so right at the outset, I want to make sure that you understand that, you realize that that environment exists, but don't be intimidated by it. Even though it's easy for me to say, it's something you have to keep in the back of your mind and always just think about it. All states require the condemning authority to initiate some negotiation process with the property owner before they can go through and actually initiate the condemnation. And in later series, we will talk about the strategies involved with that. Right now, all I want to address is to say that when that negotiation procedure has ended and the title does pass, I believe all states, as far as I can know right now, do require that there has to be a payment, a good faith payment, based upon what they believe through appraisals the value of the property is. That payment either has to be made to the condemnee, the property owner, or paid into court for the property owner to make a claim against and have it recovered. So, because a lot of people have asked me, well, Dan, if I don't agree with the government, I'm never going to get my money. And I say, no, that's not true. If you don't agree with them, and the property is taken through eminent domain, the condemning authority has to pay what at least they believe is the fair amount for the property that is being taken from you. Now, it may be a lowball offer, maybe a lowball amount, and certainly would justify then pursuing a claim, but in any event, they cannot withhold all the money. They have to at least pay that. And the procedure that goes on to basically recover the claim only involves the difference between what they have paid either to you, the property owner, directly or into court, and what the ultimate claim amount is that you as the property owner are claiming in your particular case. So that's an important point to remember. Another important point to remember that a lot of people ask me, is there any way that by making a claim that you can hold up the process and put pressure on the condemning authority to come around to your way of thinking? Unfortunately, the answer to that is no. You can't do that. The way the process is set up is that once property title to the property is passed under either of the two procedures which I've talked about, that's the end of, I guess, the stalling, if you will, from your perspective in terms of trying to create leverage that way. Title passes, the government is able to go on and do their project, and you and your claim still are allowed to proceed, but it proceeds independently of the condemning authority's right to proceed with developing their property on the project that they've taken from you.